limiting of judges on an individual basis, but rather the nationwide injunctions, which was a bill that was passed out of the House. And with that, I go to the gentlelady from California.
Thank you, Mr. Chair. And, thank you to the two of you for showing up here today, because it sounds to me like you all are asking for money. You need money for buildings, for cybersecurity, for security, and for people. And I applaud you for asking for more money for security, because one of my Republican neighbors has a wanted poster outside his office with pictures of 18 judges, 9 of whom are Republicans. And it's very scary to me and to all of the folks who are walking the halls visiting us to see. But I want to talk about the people. And the chair of this full committee just mentioned Defender Services, and that's what I want to talk about. Because in my mind, the fundamental right to a defense is what is on the chopping block. So Judge St. Eve, my understanding is that you were in AUSA, correct?
Correct.
Okay, and Judge Scudder, you too were in AUSA, correct?
Correct.
New York and Chicago is what I read. And so for the regular people listening, like me, an AUSA is a prosecutor. And my understanding is that prosecutors are assigned a caseload. Is that also correct?
That's correct.
Okay.
Yes.
Judge Scudder, okay, great. And so caseloads are a direct result of investigations done by special agents, by agencies like the FBI, like the IRS, that are doing their due diligence and helping to present evidence for a case. And so you all may not want to answer this question, but I am sure that you all became better prosecutors, which probably enhanced your ability to become a judge because of the defense world. And many of these folks that I'm talking about are the federal public defenders, the community defenders. And I'm going to say that you probably became better because you had a skilled opponent. You had to work harder, you needed to have counter arguments, you needed to be well read and prepared, and I bet that you learned how to prepare to be a judge because of your time in the courtroom and preparing for a trial. And I think those are all skills that we would want in our judges. So I actually think proposing what these Republicans are proposing to do to cut Defender Services is really hypocritical. Because essentially you're saying we don't want the next group of judges to be prepared for their job. We are going to cut up and coming AUSA's opportunity for growth because we're going to be cutting public defenders. And that's not even talking about how this goes against the Constitution, which as I read it says that you get due process, you get speedy trials, and you get effective counsel. I'm talking about a much bigger problem. Because suffice it to say, if you cut public defenders, if you cut defense, then not only are you abandoning the Constitution, but you really are going to eliminate the need for judges. And then everybody can turn the black robes in, because you can't do anything if you don't have defense. And in my mind, that is a very slippery, dangerous, surreptitious slope to be on. So Judge Scudder, as an AUSA, I'm assuming that your docket included both civil and criminal cases, correct?
Mainly criminal.
Okay. And so my understanding is that the priority are the criminal cases because of speedy trial rights. And a speedy trial is dependent upon a qualified defense attorney who can advance a case, who knows the value of a case, who understands pretrial services, and who can work with and manage interpreters, investigators, witnesses, and the prosecution. And investigators and interpreters are also on the chopping block right here. And a case cannot be adjudicated without a defense attorney, without public defenders, without these community public defenders. You can't enter a plea, you can't even go to trial without a defense attorney. And these cuts, for the record, these cuts, public defenders, CGAs, well, not CGAs, but public defenders and community defenders, would stabilize the courts and upend your calendars, because the cases that have to move the fastest would stall, and those are the criminal cases. And I want to say, in 23 and 24, there were 66,000 criminal cases filed and 113 pending. There were 347,000 civil cases filed and 633,000 pending. And you know who needed public defenders? The January 6ers. I want to enter into the record, Mr. Chair, from the national memo. Public defenders do more for January 6 suspects than Trump ever will. 60% of the January 6ers had a public defender as their counsel.
Without objection,
Thank
it will
you.
be placed in the record.
Thank you so much, Mr. Chair. I know that my time is up, but I just want to say, even Trump said that it was defense counsel. It was his defense counsel where he learned that the FBI was making mistakes, procedural and substantial misdirection. I'll be nice and say it that. He was able to uncover partisan blind spots and bring them to light because of defense counsel. And Republicans want to cut this money. That is not just stated in the Constitution that people have a right to, but it is the only thing that keeps the courts going. And with that, I yield back.
I thank the gentlelady. I'm now recognize myself. And I'll note that the Criminal Justice Act of 1964 is when we began paying